Good afternoon po. Ako po si Ashlers and Flores ang magre-report sa first half ng discussion about obligations of the partners section 2, which is property rights of a partner. After natin malaman ang mga obligations ng mga partners sa bawat isa, next naman ay yung topic tungkol sa mga karapatan ng isang partner sa partnership property ng business nila. So under Article 1810, the property rights of a partner are number 1, his rights in specific partnership property. Number 2, his interest in the partnership. And number 3, his right to participate in the management. Ang mga nabanggit ay specifically categorized as principal rights. Meron din silang iba pang rights tulad nung the right to true and full information na nakakaapekto sa partnership at marami pang iba na nabanggit na ng mga previous reporters natin. Para mas madaling maintindihan, gumawa na lamang din po ako ng mga illustration sa pag-explain ng concept. So sa number 1, ulitin natin ito yung karapatan ni partner sa specific partnership property. May tatlong requisites sa subject. Una, pag-aari ni partnership as a juridical person yung property. Sunod, tangible things yung tinutukoy. At last, ay specific in nature o determinate yung asset. Example, si partners A, B at C ay nag-contribute ng truck, parcel of land at pera respectively sa ABC partnership na binuo nila. Dito, lahat ng contribution nila ay property na ni partnership. Accordingly, sila partners ay may co-ownership sa mga ito as they use it for the operation of the business. Nalaman natin noon na ang concept ng co-ownership ay hindi nangangahulugan na may partnership na. Bagamat ang bagay na ito ay isa sa mga itinuturang essential elements of partnership. Kaya sabi ng batas, bilang isang partner may karapatan siya sa partnership property kahit hindi ito yung kinontribute niya. Therefore, si A, B at C ay may rights over the truck, land at cash ng business. Number 2, pag may contribution, may interest sila. Halimbawa, ang napagkasundo ang value ng land ni D na kinontribute niya ay 500,000. 300,000 naman daw yung truck ni E at 200,000 worth of cash kay F. Obviously, ang interest ni D sa partnership ay 50%, si E ay 30% at ang natitira ay kay F. Dito binabase yung share nila sa profit and loss at residual interest ng bawat isa. Pero kapag industrial partner, may share pa rin sa profit, 'di ba? Kasi may agreement naman sila tungkol doon. At nabanggit na ito sa mga previous topics. Lastly, the rights to participate in the management. Kapag walang stipulation kung sino magiging manager, ibig sabihin lang nun na lahat sila, si partners G, H at I, ay pwedeng mag-perform ng lahat ng mga acts of administrations. Pero kung merong na-appoint na managing partner, isa o higit pa, either sa articles of partnership o after ng constitution ng partnership, siya o sila ang may karapatan sa management dahil sa mutual agreement ng lahat ng mga partners. And he or they must comply to various and different rules. May nabasa rin po ako na ang mga limited partners ay maaaring mag-contribute ng money or property pero hindi yung service sa management halimbawa. Next naman po, additional info lang dahil nakita ko po ito sa book ni De Leon. Dahil minsan nalilito between partnership property at partnership capital. Para mas malinawan, may two major differences sila. Una, sa value. Ang market value ng partnership property ay nagbabago from day to day. Kaya meron tayong tinatawag na revaluation of assets. Samantala, yung partnership capital ay constant lang sa paglipas ng panahon. Yung amount nito ay hindi nagbabago dahil fixed yung agreement ng ginawa ng mga partners which is hindi rin naapektuhan ng fluctuations sa value ng partnership property. Katulad sa example illustration, maaring bumaba o tumaas yung sa partnership property unlike sa partnership capital na mananatili yung value mula constitution of partnership hanggang dissolution or liquidation. Tapos, mas malaki rin yung sa partnership property kasi nakapaloob dito yung mga kinontribute nila partners plus any subsequent acquisition of assets gamit yung partnership funds or sa account ni partnership. Samantala, yung partnership capital, ito lang yung pinagsama-samang individual contributions ng mga partners. Maaaring cash, property, or services at fixed yung value dahil sa agreements. So sa partnership, ito ay mas broad kaysa partnership capital. Meron din po doon yung topic about ownership of certain property. May 4 list of determinants. Number 1, property used by the partnership. Number 2, property acquired by a partner with a partnership in partnership funds. Number 3, property carried in partnership books as partnership asset. And and number 4, other factors tending to indicate property ownership. Ang mga examples ay sa next slide. So, yung ginagamit na property na partnership ay pwedeng nasa kanya yung ownership o kay partners. Tulad ng si Universal Partnership of Profits, bukod sa profits or income ang pinaghahatian, ang usufruct o paggamit lang ng mga asset ang natatransfer. So, halimbawa, ginagamit sa business yung truck ni Jay. Pero si Jay pa rin ang owner, which is not unusual for an individual partner na i-allow niya yung property niya to be used in the business operation. So, yung intention ng mga partner whether to transfer ownership o hindi ay yung controlling factor na makakatulong para malaman kung sino ang nagmamay-ari sa specific property na in question. Next naman, kapag in-acquire ni business entity under its name yung truck gamit ang partnership funds through a partner who act as an agent, technically ang ownership ay kay partnership bilang isang juridical person that is separate from his owners. Kapag naman naka-appear sa book ni PQR partnership yung property, sa kanya yon. Para naman kapag funds nga ni partnership yung ginamit pero para lang i-repair or sa maintenance ng property. Consequently, hindi ito sufficient basis or evidence na si partnership ang may title dito, kundi kay partner pa rin na nagpagamit lang nun to be used in the business. At marami pang ibang case scenarios. So, moving on, as stated in Article 1811, a partner is co-owner with his partners of specific partnership property. The incidents of this co-ownership are such that, number 1, a partner, subject to the provisions of this title and to any agreement between the partners, has an equal right with his partners to possess a specific partnership property for partnership purposes, but he has no right to possess such property for other purpose without the consent of his partners. Number 2, a partner's right in specific partnership property is not assignable except in connection with the assignment of rights of all the partners in the same property. Number 3, a partner's right in specific partnership property is not subject to attachment or execution except on a claim against the partnership. When partnership property is attached by a partnership debt, the partners or any of them or the representatives of a deceased partner cannot claim any right under the homestead or exemption laws. Number 4, a partner's right in specific partnership property is not subject to legal support under Article 291. So tulad ng nabanggit kanina na ang partner ay co-owner with his partners of specific partnership property, however, yung rules regarding co-ownership ay hindi actually ma-apply. The legal incidents of this common right in partnership are distinctively characteristic of the partnership relation. They are as follows. Una, equal right of possession for administrative and management of that specific partnership property for partnership purposes. So basically, ang isang partner ay may karapatan sa mga specific partnership property na gagamitin sa pagconduct ng business operation. Kaya kung ang VWX partnership ay may pagmamayaring property like delivery equipment and land, lahat sila ay co-owner ng mga ito. Pero wala ni isa sa kanila ang may karapatang gamitin ito sa ibang bagay, personal matter for example, without the consent of his partners. Kapag may tumaliwas at ginamit ito halimbawa yung land for his own profit, under Article 1807, he is required by the law to account all the profits na nakuha niya mula sa paggamit ng partnership asset na ito. For instance, V, W, and X entered into a contract of partnership. Si partner V ay nag-contribute ng truck niya. Kay W naman ay parcel of land at 200,000 worth of cash mula kay X. Lahat ng contributions again ay pagmamayari na ni V, W, X partnership being a juridical person. Dito pwedeng gamitin ni V or W or X ang 200,000 na business fund sa pag-purchase example ng office supplies, but not for personal purposes. O di kaya yung land for warehouse of the partnership goods. Pwede rin yung trucks pag-deliver ng mga commodities, but again, not for personal purposes hanggat walang consent ng ibang co-partners. Number 2, a partner's right in specific partnership property is not assignable. Assignment, in the law parlance, ito yung pag-transfer ng rights or property ng isa o ng mga partners. Ang sabi sa Article 1811, partners Y or Z cannot assign his right on any of their contributions. Pero, kung lahat sila partners ay sama-samang involved, pwede. Dahil ang beneficial interest ni partner sa specific partnership property ay undeterminable until after the liquidation of partnership affairs. Bukod pa doon, ang mga primary reason for the non-assignability of rights ay una, Dahil pagmamayari yun ni business firm. Tapos para maiwasan ang interference ng mga outsiders sa partnership affairs at para maprotektahan ang iba pang partners as well as the partnership creditors at may apply ang mga partnership assets sa partnership debts. Next, a partner's right in specific partnership property is not subject to attachment or execution. Execution, ito daw po yung gagawin na dahil may order ni court. So, halimbawa, i-liquidate na daw yun or minsan binibenta sa mga public auction. Sa attachment naman, example ay si A as one of the partners in ASH partnership ay may unpaid debt sa personal creditor niya. Halimbawa, wala ng cash na pambayad si A, sabi niya. Hahanap ngayon si creditor ng property ni A. Tapos nalaman niya na may interest ito sa ASH partnership. Pero dahil ang mga property ay hindi ko consider as separate property ni A dahil pagmamayari ito ni business firm, therefore hindi pwedeng i-attach ni A as payment kay creditor. Pwera na lang kung for claim against the partnership yon. At dahil ang tinutukoy lang dito ay residual interest ng mga partner pagtapos na mabayaran lahat ng mga debts ni partnership. Tapos may mga co-owner din kasi siya. Siyempre hindi sila pwedeng madamay sa personal conflicts ni partner/debtor. Sa number 4 naman, a partner's right in specific partnership property is not subject to legal support under Article 291. Ganon din po sa revised Family Code na Article 195 about dun po sa obligation ng mga relatives na maaaring magbigay ng suporta ang bawat kamag-anak sa kapamilya nila. Pero dito sa Article 1811, hindi pwedeng suportahan ng kamag-anak ang isang partner sa right nito sa specific partnership property. So, ito pala yung example. Next, ay last na. According to Article 1812, a partner's interest in the partnership is his share of the profits and surplus. Dun sa example natin sa number 2 sa Article 1810, gamit yung agreed value or exact value ng kinontribute na capital, malalaman yung interest ng isang partner sa partnership. Tulad ng sabi kanina, kapag walang stipulation regarding the sharing of profit and loss, ibabase sa contribution ng interest. Before, nasubukan na rin natin mag-compute ng share sa profit and loss to be distributed to the partners sa Accounting for Partnership and Corporation subject. Sa profit, dinescribe ko siya using locked icon. Kasi nag-ooperate pa si business firm. Tapos, ito yung pinaghahatian ng mga owners as effect of the performance of business. Ibig sabihin, ito yung excess sa revenues na na-earn after deducting all the expenses incurred in the operation during a certain period of time, usually one accounting period. Net loss naman kapag mas malaki yung expenditure kaysa sa revenues. Whereas in surplus, I describe using an unlocked icon. Dahil dito, dissolve na ang partnership para malaman na finally yung surplus or funds na natira pagkatapos masatisfy ang claims sa outside and inside creditors. Ito yung excess of the firm's assets over its liabilities. Equity kung tawagin din. Again, the profits is shared in conformity with the agreement, otherwise in proportion to the capital contributions. Also, according to Article 1797, the industrial partner shall receive profit using the concept of JES or under just and equitable circumstances. Dito sa article na ito, pwedeng ma-assign or ma-attach ang interest ni partner sa partnership yung profit and surplus. Unlike sa right niya sa specific partnership property na hindi subject to attachment and assignment dahil it is impossible to determine the extent of his beneficial interest in the property. At pagmamayari rin kasi yun ni business entity. So malalaman lang ito pag dumating yung araw ng liquidation of that specific partnership. And that would be all. Thank you for listening. Have a nice day.